Today, you're going to find out what it really looks like when a big corporation attempts to bully a smaller firm through a frivolous lawsuit.
I mean, Nike and Adidas are always suing people.
I thought this was an interesting story taking place in the sneaker community that would provide some insight into intellectual property law and how smaller companies defend themselves against the larger corporations. And because it's good to take a breather from the fake gurus and influencer drama every now and then, I hope you enjoy it. Let's begin.
I see this as Nike stifling creatives and being overbroad with their enforcements of intellectual property, and specifically elements of the trade dress.
With Nike's company revenues reaching all-time highs nearing $18 billion a year, you wonder why they're spending time filing frivolous lawsuits. Shouldn't they be more worried about employee retention in their sweatshops than a smaller company in the luxury shoe space?
In my humble opinion, I believe that John Geiger Collection LLC was included in this complaint because of the other defendants involved in the suit.
What you'll find in this story is a behemoth corporation attempting to prohibit a competing shoe company from designing their own shoes by claiming their famed Air Force One and Dunks were infringed upon. They didn't realize that the smaller company was able to put up a fight. Here is the filed complaint between Nike and defendants LaLaLand and John Geiger Collection LLC. In order to understand how John Geiger Collection LLC was included in this amended complaint, we must first establish who their co-defendant is, LaLaLand Production and Design. For you lovely ladies out there, unfortunately, this company does not have a dancing and singing Ryan Gosling inside its offices. LaLaLand's website describes itself as a manufacturing gem in downtown LA's exciting arts district and touts the ability to label its products with Made in LA, Made in USA. LaLaLand promotes its ability to manufacture a wide range of shoes, from boots to sandals to sneakers and everything in between. In addition to in-house counsel, John Geiger was looking to add more firepower to his defense team and was able to hire the guy who literally wrote the book Sneaker Law.
There really are two cases brought by Nike here. So there's the first one for infringement against LaLaLand for manufacturing the Warren Lotas sneakers, which Nike believes infringes on their swoosh mark and their dunk trademarks.
Let's establish the characters in this story. LaLaLand is the manufacturer capable of producing apparel, shoes, and sneakers for multiple companies. Warren Lotas is an apparel and sneaker company that was sued by Nike for trademark infringement. John Geiger Collection LLC is a luxury shoe company not associated with Warren Lotas at all, but is being accused of trademark infringement as well.
So there is no relationship between Warren Lotas and John Geiger Collection LLC. The only common factor between the two companies is that at one point they both worked with LaLaLand on developing a sneaker.
Nike alleges, like Warren Lotas, John Geiger has attempted to capitalize on the strength and fame of Nike in its Air Force One trade dress by making, promoting, advertising, marketing, and selling in the United States footwear bearing the Air Force One trade dress and/or confusingly similar trade dress. The definition of trade dress is the design and shape of the materials in which a product is packaged. Product configuration, the design and shape of the product itself, may also be considered a form of trade dress.
And the second one is for infringement against John Geiger Collection for selling the GFO1, which Nike believes infringes upon their Air Force One trademark.
At the heart of this case is Nike defending itself against potential trademark infringement. Makes sense. When you're a $265 billion company, you're going to protect the design of your products. In a creative environment, there's always going to be a battle between influence, likeness, and similarities. Now, let's take a look at a sneaker that shared a little too much likeness with the Nike Dunks. The shoes in the middle column are the Nike Dunks. The shoes in the right-hand column were made by the company Warren Lotas, who was accepting pre-orders for this sneaker.
And so he took a sizable pre-order, which what I think caught Nike's attention. And so before he actually manufactured the shoe, Nike swooped in with the lawsuit, stopped the production of the shoes.
Paragraph 73 includes the volume of shoes produced by LaLaLand and sold to Warren Lotas. 1,500 pairs totaling $115,500 of the Jason SB Dunk Low, 2,001 pairs of Jason SB Dunk Low Toxic Green for $162,081, 20,574 pairs of Freddy Broccolini Chanclas sneakers totaling $1,522,476. I think a reasonable adult can look at these drawings and agree that Nike had a strong case that Warren Lotas was infringing on their trade dress for the Nike Dunks. I hope everyone looking at the screen right now laughed as hard as I did when I first saw this image, thinking, how in the world does Warren Lotas think they're going to get away with this?
Now, Nike only recently added John Geiger to the case by amending their complaint against LaLaLand. This happened almost 8 months after the initial lawsuit against LaLaLand.
When I was first presented with this case, I saw the Warren Lotas sneaker and then thought that John Geiger shoes would be similar because they got thrown into the same lawsuit, right? Here's the image provided by Nike in their complaint alleging that John Geiger's GFO1 sneakers located within the right column is infringing upon the Nike Air Force One sneaker, which can be seen represented in the middle column. Admittedly, I'm not a sneakerhead and am not familiar with every aspect of the production of a sneaker, so a blind eye can see similarities, but upon further inspection, they're not all that similar. Within John Geiger's motion to dismiss, they provided two images representing the differences between the shoes in question, John Geiger's GFO1 sneaker and Nike's Air Force One. In Figure A, there are 8 noticeable differences between the two sneakers, and Figure B represents the difference in the bottom of the shoe.
Well, Nike can claim trademark infringement over parts of a shoe. That is, in fact, what they're arguing here. So the Air Force One trade dress actually only protects certain parts of their sneaker, not the whole sneaker as a whole. We're arguing that those individual and limited elements are not similar to the Geiger sneaker, and that Nike, in essence, is doing a poor job protecting their trade dress because so many other companies are using those design elements on their shoes.
What almost can go unmentioned is the fact that Nike is such a large established brand that a shoe not having the swoosh is pretty universally acknowledged as not being a Nike. What I was able to understand from both attorneys is that an important factor in defending John Geiger against the trademark infringement claims is determining if there was confusion in consumers' minds between two competing products, the Nike Air Force One and the John Geiger GFO1. Here is the best defense John Geiger Collection LLC can make.
That there is no likelihood of confusion whatsoever for a consumer. A sneakerhead is the most sophisticated, or one of the most sophisticated consumers in the retail, wholesale, commercial space. A sneakerhead will wait days at a time and know exactly the shoe that they're going to be waiting in line for, waiting in the cold for, or staying up all night to try to get a passcode or access, online.
A strong defense claim that John Geiger Collection LLC can make is that consumers have to take multiple steps in order to purchase a shoe from their company. The competing shoes in this case are not sold in the same retail or e-commerce location. They are sold at different price points, and there is no reason to believe someone shopping for a John Geiger shoe would misinterpret any as a Nike, given the process one has to take in order to purchase a GFO1.
I'll show in regards to just what a consumer would be getting in this instance. A beautiful registered trademark of John Geiger Collection, the JG, which is prevalent throughout many of our gear. You can see it on the shorts, you can see it on our socks, and you can see it on our shoebox. So in this instance, you're not going to be seeing any confusion. Here, as a consumer, you open up the shoe and you see our registered mark again. Beautiful registration on packaging and a lovely gift for any sort of family member, and the beautiful GF1 with our own registered marks on the bottom of the sole.
From my point of view, Nike's position is pretty weak given that consumers are never in a position to make the decision between a John Geiger GFO1 and the Nike Air Force One. From my perspective, it would be like driving 30 miles away from your destination and complaining that the video game store you arrived at doesn't sell pizza.
Now, what is likelihood of confusion? Well, in this case, to put it simply, Nike has to allege facts that show that customers viewing the GFO1 Geiger shoe would assume that it's associated with Nike and the Air Force One. Now, our argument is that Geiger's customers are smart enough to know that they're not buying an Air Force One when they buy a Geiger GFO1. Not to mention, they're not even sold in the same place at the same price or have the same branding, so it's impossible to show a likelihood of confusion here.
Nike alleges that sneakers bearing Nike's trademarks that LaLaLand manufactures, sources, or otherwise provides, such as the sneakers shown above that LaLaLand sold to Warren Lotas and John Geiger, cause confusion in the marketplace regarding whether they are legitimate authorized customizations or illegal fakes.
Well, on the original Warren Lotas sneaker, he used a confusingly similar logo to the swoosh mark and the exact same pattern as the Nike Dunk. The soles were identical, the uppers were identical, and just about everything was the same as the Nike Dunk. On the GFO1, Geiger used his own pattern, his own trademark logo, his own proprietary rubber sole mold, insoles. I mean, the whole shoe is redone from top to bottom. In Geiger's own words, it's only inspired by the Air Force One, but it's not a knockoff.
Nike throwing a frivolous lawsuit at a smaller firm to attempt to shut down a competing product seems to be right out of Chapter 1 in the Behemoth Company Corporate Tactics book, but what's most upsetting to hear is that John Geiger actually helped make Nike a lot of money a few years ago.
So the court will decide this one, but at the end of the day, the real customers know what's legit and what's not. John Geiger's been influencing the sneaker game for a long time and has done a lot for Nike. In fact, Nike's benefited from his designs and creativities for years. They're still releasing sneaker designs that Geiger came up with and not giving him any credit. So for them to try to come after him now for his uniquely branded GFO1, while other brands are still allowed to make their almost identical Air Force Ones, it just goes to show that the Nike legal team really doesn't think these things through.
Here's a YouTube review video for the misplaced check shoes created by John Geiger.
Sure. So Geiger is very well known for creating something called the misplaced checks. In his early customizer days, he created Nikes, which were legit or authentic Nikes, but he cut the stitching off, he took the swooshes off, and he placed them in odd places on the shoe, places that Nike would never have done on their own. In fact, before he even sold these things on his own, he went to Nike and he said, how about doing these designs? And they said, no, we'll never put the Nike anywhere else but where it's usually placed. Years later, now they're releasing the Sakai waffles, they're releasing the Sakai blazers, checks are all over the place. They've now changed their tune because of Geiger's influence. When his shoe came out, people went crazy for it.
There are certainly some similarities between the Air Force One and the GFO One, seen mostly when the colors match, but I think John Geiger Collection LLC has a strong case to defend itself against the trademark infringement accusations. From an outsider, hearing that consumers aren't able to buy John Geigers at a retail store, are never in a position of having the Air Force One and GFO One on the same shoe rack, and can only order the GFO One on John Geiger's own website, makes it hard to believe that Nike has a strong case here.
We're ready to fight this case to the end because ultimately we're here to protect the creatives. These are the people that are coming up with the amazing ideas so that they can build the next Nike. We're here for it.
What drew me to this case was my strong disinterest in censorship, YouTube copyright strikes, trademark infringement, and larger corporations sending lawsuits to smaller companies who are significantly more affected financially by a lawsuit than a $265 billion company. I fully support protecting your copyright when someone is trying to downright steal it, like in the case of Warren Lotas, or a YouTuber taking half of your content as their own. I'm all for taking legal action against obvious theft for sure, but I very much dislike hindering creatives, as I think the best art is influenced by the art that came before it, and stifling that leaves everyone worse off. I hope you enjoyed the video. It was a little different, but I thought it was an interesting story to share. Thanks for watching.